Labor legislation. It is used to cover all the laws related to employment, working conditions, wages and salaries, social security, and industrial relations of the workers employed in the industry. It provides a legal weapon in the hands of employee against wrong or harsh treatment rendered to him by the employer. According to Mr. V. Giri, it is a provision for equitable distribution of profits and benefits emerging from industry between industrialists and workers and affording protection to the workers against harmful effects to their health, safety, and morality. Importance of labor legislation. Improves industrial relations, minimizes industrial disputes. Workers are entitled to a job security, promotes healthy work environment. Employers cannot take undue advantage of employees by making them work overtime and not providing compensation for the same. Removing the economic insecurity of the workers. Objectives of labor legislation. Establish and facilitate social, political, and economic justice to both the employer and employees. Provide job and economic security to the workers in the times of cutthroat competition. Provide the rights to government to interface in case it senses disharmony among the employer and employees. Maintenance of good relation between employer and employee. Provide equal job opportunities to all irrespective of gender, caste, culture, and creed. Principles of labor legislation. It is divided into 4 parts: social justice, social equality, national economy, international conventions. First, social justice. It aims to provide justice to everyone in the society equally. It is important to ensure that poor are not exploited by rich. The profits and benefits must be equally distributed among the workers. The workers need to be provided safe and good working conditions at their workplaces. Second, social equality. This principle focuses on ensuring social welfare of the workers. It focuses on issues of wages, safety, working hours, and health facilities, etc. It is helpful in improving the social status of workers by improving their economic status. Third, national economy. This principle ensures industrial peace and industrialization of the country. The legislation needs to ensure the holistic development while focusing on the individual industry and nation as a whole. Fourth, international conventions. Here, conventions means a meeting or a formal assembly. International Labour Organization has played an important role in standardization of labor laws across the countries. Its conventions regulate different aspects of labor laws. The country's labor legislation needs to be guided by this convention. Classification of labor legislations. Laws related to industrial relation. Example, Trade Union Act 1926. Laws related to wages. Example, Payment of Wages Act 1936. Laws related to working hours, condition of service and employment. Example, Factories Act 1948. Laws related to equality and empowerment of women. Example, Maternity Benefit Act 1961. Laws related to social security. Example, Workmen's Compensation Act 1923. Laws related to prohibited labor laws. Example, Child Labor Act 1986. Laws related to employment and training. Example, Apprentices Act 1961. Laws related to deprived and disadvantaged sections of the society. Example, Bonded Labor System Abolition Act 1976. Type of legislations, that is regulative, protective, wage related, social security, employee welfare. First, regulative. It focuses on relations between the employer and employee and provide methods for settling industrial disputes. These laws lay down the rights and duties of employers and employees. These include the Trade Union Act 1926, the Industrial Dispute Act 1947, etc. Second, protective. It focuses on protecting labor standards and improving the working conditions. This include Factories Act 1948, the Mines Act 1952, etc. Third, wage related. It focuses on the minimum wages that must be paid, methods and manners of their payment. This include the Payment of Wages Act 1936, the Minimum Wages Act 1948. Fourth, social security. It focuses on providing social security to the workers. This legislation protects workers against risk of undue hardship and privation. This include the Workmen's Compensation Act 1923, the Employees State Insurance Act 1948. Fifth, employee welfare. It aims to help employee in leading a better and good life with improved standard of living. This include BD Workers Welfare Fund Act 1976, the Mica Mines Welfare Fund Act 1946. Evolution of labor legislation. The laws were enacted by the British to safeguard the interests of British employees. Indian textile industry was offering tough competition to British textiles. This led to the introduction of the Factories Act 1883, which aimed at making labor costlier in India. Factories Act 1883 for the first time abolished child labor, fixed the working hours for 8 hours and introduced the concept of overtime wages for work beyond 8 hours. For the first time, Trade Dispute Act 1929 focused on the relationship of employer and employees. This act also laid down the provisions of restraining the rights of strike and lockouts. This act was repealed in the post-independent era and Industrial Dispute Act 1947 was brought into force. Bombay was the pioneer in the formulation of legislation on labor. This was followed by enactment of many laws concerning social security and regulation of labor employment. India has been providing for core labor standards of ILO for welfare of workers and to protect their interests. Indian Constitution and labor laws. Labor laws enacted by the central government, where the central government has the sole responsibility for enforcement. Labor laws enacted by the central government and enforced both by central and state government. Labor laws enacted by central government and enforced by the state government. Labor laws enacted and enforced by the various state governments which apply to respective states. Labor has been included under the concurrent list, List 3, in the 7th schedule of Constitution of India. A concurrent subject is a matter for which both the state and central government can enact laws. In the case of labor legislation, there is a clause which says that state cannot enact a law which is repugnant to the center. Here, repugnant means objectionable or offensive. Fundamental rights. It is mentioned in Chapter 3 of Indian Constitution. It deals with the relevance of the dignity of human labor and need for protecting and safeguarding the interest of labor as human beings. Article 14 mentions deals with equality before law. It prohibits any discrimination on grounds of religion, race, caste, sex, or place of birth. Article 16 mentions deals with providing equality of opportunity in matters of public employment. Article 19 mentions provides rights regarding freedom of speech and expression. Article 23 mentions prohibits human trafficking and forced labor. Article 24 mentions prohibits the employment of children below the age of 14 years to be employed to work in any factory or mine or engaged in any other hazardous employment. Directive Principles. It aims to provide the following to the citizens of the country: health and strength of employees, men and women, prevention of child abuse, humane conditions of work, secure participation of employees. It is mentioned in Chapter 4 of the Indian Constitution. Article 38 mentions government shall promote the welfare of the people by securing and protecting as effectively as it may a social order. Article 39 mentions men and women have equal rights to an adequate means to livelihood, equal pay for equal work for both men and women. Article 41 mentions provides right to work, to education and to public assistance. Article 42 mentions vouches for just and humane conditions of work and maternity relief. Article 43 mentions government should work to provide all workers, agricultural, industrial, a living wage, etc., ensuring a decent standard of life. Article 43A mentions deals with participation of workers in management of industries. Thank you.